Holland Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to our third episode in our Beyond Compliance Leading Workplaces Through Change podcast series, where we'll discuss the key issues leaders in workplaces around Australia are grappling with right now. Whether you're navigating workplace change and disruption, restructures and redundancies, managing psychosocial hazards, or dealing with complaints, this is the Workplace series for you, and we've got you covered. I'm Faye Calderoni, a partner in our employment team and co-lead of our Beyond Compliance offering for boards and executives. I'm your host for this episode, and today I'm delighted to be joined by my colleagues in the National Employment Team, Special Counsel Sean Sullivan from our Brisbane office, and my partner in Sydney, Claire Curley. Welcome.
Hi.
Thanks for having us.
Faye.
Thanks for having us, Faye.
Great to have you on board. It's a really tricky one that we're unpacking today. We're putting reasonable management action under the microscope. The fact is most claims don't start with bad intent. They start with poor processes and ineffective communications that breaks trust and breeds fear. In this episode, we'll unpack the grey areas, the moments where good intent meets bad outcomes, and explore how employers can navigate that fine balance without things backfiring and ending up in legal claims and risks. We've got lots to cover, so I think we should just get started now. We often hear about reasonable management action, and it's used as if it's settled law, but we know in reality in workplaces there's a lot of grey in it, and it's unclear what makes actions reasonable. So how much of this does depend on the perspectives of the manager, employee, or regulator looking back in hindsight? I think for that question, I'm going to start with you, Sean.
All right. Thanks for that, Faye. So by way of my background, I come from a practice that is predominantly work health and safety and workers' compensation. I'm more of the employers reacting to the crisis situation than rather trying to head off the crisis in the first place. And reasonable management action it's very formulaic. It's a precise formula in our field of law. The reasonable management action, the courts have said that, first of all, reasonable doesn't mean perfect, but it's meant to have an objective test that if anyone looking from the outside in would examine the actions taken, they'd say that's a fair deal for all the parties involved. Unfortunately, there's a lot of disagreement between parties, both those conducting the management action, those requesting the management action, those receiving the management action, as to what is a fair deal. And there's often a difference of opinion between the different regulators, whether they be workers' compensation regulators, work health and safety regulators, the courts, or the commissions, as to what is reasonable. So unfortunately, it's meant to be an objective test, but everyone seems to take their own opinion. It's not meant to be in hindsight. It's not meant to be perfect, but it's meant to hold up to external scrutiny. I think Claire's probably better placed to comment on what constitutes a management action. I can tell you what is often not considered management action, but that's from when it's fallen down later on in the litigation process.
That's what I was going to say, our proactive queen and advisor to all people that are leaders and HR professionals stepping in. How do you construct this to make it stand up in court from the outset?
Yeah, thanks, Van. Thanks, Sean. Look, going off what Sean just said, one of the biggest misconceptions about reasonable management action is that the employee has to agree with the decision. It doesn't mean that at all. The law doesn't require managers to be popular or cool. It just requires them to be reasonable. And I think a really useful way to think about it is when approaching management is to ask yourself two questions. Is the decision reasonable? So what I'm going to do reasonable? And then is the way I'm going to implement it reasonable? So it's a two-stage process to think about. An employer can have really legitimate concerns about performance or conduct or attendance, all of that, but it still creates problems the way it is addressed, despite the legitimacy of the concerns. For example, performance feedback is absolutely not bullying. However, publicly humiliating someone while giving the feedback is. So the challenge is, and this is just as Sean said, everyone sees the situation differently. We all come from different backgrounds, different walks of life. We hold different values. The way we look at the world is shaped by many different things. And the manager often thinks, I'm just doing my job. But the employee who sees their own performance as no issue thinks they're being unfairly treated or targeted. And then months later, a court or a commission, as we frequently deal with, comes along and asks the further question, would a reasonable person consider this reasonable in the circumstances? Hindsight is dangerous sometimes in these things. A Fair Work Commissioner never has to manage a team on a Friday afternoon, 3 people off sick, a deadline's due, got to get this performance management done. But employers also need to remember that these judges and tribunal members examine every email, look at every action and consider every text message with somewhat forensic precision. So the practical question you're asking yourself, it's not, am I right? It's, can I explain I acted the way I did? Can I show I acted fairly?
You're absolutely right, Claire. And it's so true. Quite often when we do have these claims or complaints arising from performance management, it's not about the substantive reason for it. It's about how it occurred, whether it was in a reasonable manner and over a Teams meeting with others present isn't reasonable. In a car park on the way home isn't reasonable. In a corridor or in the kitchen isn't reasonable. And so you have something that is otherwise subject to scrutiny would be okay and would be perceived reasonable, and it falls down in the delivery, which does come back to this communication issue. I want to stay with you for the next question, Claire, because I do think that it's something that we see all the time, and that's that most managers are genuinely trying to do the right thing. So they're either addressing performance or addressing conduct or behaviour, or even in the context of restructures, starting genuine conversations. But quite quickly, we do see these discussions, these objective discussions, escalate to complaints. And I think we can take a cynical view about that, and there probably is some room for cynicism in the current environment. But what do you think are the key moments where things really go off track, and what can employers and leaders do to shield themselves from that happening?
Yeah, look, as you said, Faye, absolutely. Most workplace disputes don't start with malice. No manager, or it is very rare to see a manager engage in a performance management or a conduct management process maliciously. What they do start with, though, is avoidance. Managers sometimes delay the difficult conversations because they're uncomfortable, they don't like confrontation, they're scared of being called a bully. There are many different reasons a manager avoids a difficult conversation, but you're in a position then by the time you finally act, they're frustrated, so the manager's frustrated and the employee is surprised because it's never been raised with them. And so you've started off from a relationship that's already been damaged. So in terms of your question as to what are the points, there are 4 key turning points where things go sour. The first, I would say, is surprise factor. So the employee thinks they're excellent, the manager thinks they're not excellent, and they receive a warning and they say, this is the first time I've ever heard of that. Even though it might not technically be true, it's a big red flag in terms of, will you get a dispute? So good performance management should never be a plot twist. I think the second point is when process overtakes communication. Organisations are necessarily focused on compliance. They have to be, because our laws are so rigorous around these sort of things. So they've got these perfect letters, these perfect procedures, but no one explains to the people involved what's happening in plain English. So employees aren't complaining because they lost an argument. They're complaining because they feel like they weren't heard. So being really mindful of how the process is communicated is really important. I think a third turning point for when things go a bit wrong is when managers become emotional. If they feel challenged or they feel defensive or something blows back on them, the conversation suddenly changes from, let's address this issue, to, how dare you question me? I haven't done anything wrong. I'm the manager. I'm doing this. So it doesn't really end well when out of the conversation. And I think fourthly, inconsistent treatment is a really big issue. Nothing sort of fuels fire in the workplace faster than perceived double standards. I think if one employee is being held accountable and another isn't, people aren't going to debate the issue or the conduct in question or the performance in question. They start debating the fairness of it, and so things go off the rails pretty quickly. I think really the way to avoid disputes is pretty simple. It's an early conversation Don't leave it. It's clear expectations and it's genuine. Actually listen to your employee. Don't have a foregone conclusion in your head. Not every workplace problem requires a huge investigation, 12-page letters, lawyers at 10 paces. Sometimes it's just a manager saying, hey, here's the issue. Tell me your perspective and let's work out how to fix it. It's not glamorous or anything like that, but it works.
It's such a fantastic answer, Claire. You have just distilled law and the human condition in one very succinct summary. And as you spoke, and it is a sidebar, and we talk about consistent and indiscriminate enforcement of policies and procedures. But as you did say that, not to infantilize the workplace, but it does remind me of justice and that perceived injustice when you treat one sibling differently to another. It really is. It comes back to the human condition.
Yep, that's right. We're all humans, and it's a really hard thing to control, a person's perspective. In fact, you can't control it.
That's why it's called psychosocial, though, isn't it? Sean, I'm going to throw to you. When things go wrong, as they sometimes will, and this complaint comes in, what does good complaint resolution actually look like in practice? And most importantly, how should organisations respond afterwards to reduce the risk of the same thing happening again, but more to the point it ending up in a court case?
The first answer is you can never prevent it going to a court case, is my experience.
Yeah.
So that it's setting a realistic expectation within the employer and management as to they can't stop someone, they can just put themselves in their best position. That's what I always advise. A lot of what Claire said is a part of that process. It's been my observation in the cases that I've had to deal with that a lot of the times what has been a small problem has been left to fester, mainly because management has decided they think it's going to fix itself, that the problem's going to right itself, that if they leave it, that people will work it out between themselves. They put yourself in the best position involves, ironically, having a plan but not sticking to the plan. In that you need to know where you're heading and how you're going to get there, but you don't want to be dogmatic about the process. You have to be consistent in the process, as Claire said. So a lot of the cases that I see are people who have lost trust in the process because of inconsistencies, or they believe that they're being picked on because the management's not following the process to the letter. There are issues that arise about confidentiality during the investigations, during responding management action, either responding to a complaint or dealing with the person. So if you're dealing with someone who's not performing well, you want to maintain that on a confidential basis as much as it's appropriate. You don't want to broadcast it to the general world that they're being performance managed, partly for their psychiatric benefit, that they don't feel like they're being victimised, and also from the perspective of their interaction with their peers. Can I just add, there's also an issue that I found about questioning where complaints have been made, particularly in bullying cases or sexual harassment or discrimination cases, where the complainant can sometimes go off the rail because the management is not sensitive to trauma-informed questioning. It can lead the complainant to start feeling like they're being cross-examined and being questioned about, not believed in what they're saying. Now, I'm not saying that every complainant is honest and correct in what they say, but it certainly doesn't help the situation if they feel like they're fighting against both the accused and the company in getting their grievance addressed. And that can often lead to the problem of refusals to participate, either by the person who's being the management actions directed, or sometimes even by the complainants. In those circumstances where there starts to become a breakdown in the investigation or the management action process, you have to take a step back, work out whether you need to revise how you're addressing the management action, rather than keep on blasting ahead with repeating the same process over and over again. You also need to make a decision. Just because someone refuses to participate doesn't mean that the action's on hold until they do agree to participate. You act reasonably in giving them a reasonable opportunity to participate. But if after that reasonable opportunity they don't participate, you ultimately have to grasp the nettle and make a decision which you can justify based on the information that you gathered, based upon your interaction with those, whether it be the complainant or a person who's subject to management action, such that if an external person looked at it, and this is where I often step in, like an external person such as a lawyer looks at the fact situation, they could believe that action could be sustainable.
That's true. So true, Sean. And important information there around trauma-informed complaints processes too. Claire, I might throw to you just to supplement the answer, the very comprehensive answer to that question. If there's anything else you'd like to add from an employer perspective, and also most notably that given you run so many of these investigation processes for our clients.
Yeah, sure. I think in terms of that investigation piece, something that we very frequently see is people thinking the investigation is the outcome. The investigation is just the process. The question is, what happens next? I don't think a good complaint resolution isn't about making everyone happy. That's impossible. You can't make everyone happy in such a situation, really. It's about ensuring people feel the issue was taken seriously, assessed fairly, and dealt with appropriately. So, yeah, going off what Sean just said, I suppose one of the hardest conversations in an investigation process is telling someone their complaint wasn't substantiated. I think if that conversation is handled badly, you're creating a second problem after the first one. And I think another piece, and this probably goes, Faye, more to your question of how to prevent it happening in the first place or how to prevent reoccurrence, is organisational learning quite often gets overlooked. So every complaint is data. So if you're seeing repeated complaints about the same team or the same manager or the same process or workload issue, the complaint isn't the problem, it's the symptom. And so the question you should be asking is, what has allowed this issue to emerge, rather than saying, who's at fault? Who did this? Which individual will I go after? So sometimes the answer will be training. Sometimes it's leadership capability. Sometimes it's things like unrealistic workload or all those sorts of things. But if you are only investigating individuals and not examining systems, you'll just keep solving the same problem over and over.
You're playing whack-a-mole, really.
That's right, which is fun, but it'll get frustrating after a while.
I keep bringing this conversation back to an elementary level, don't I? This is what happens when you have two very intellectual people on a podcast with someone like me. Speaking of which, Sean, I am going to fix my positioning of my next question to address the earlier issue you identified and say, how do employers set themselves up for success that if they should end up in a claim, particularly a workers' compensation claim, they can most adequately defend it? What are your top tips?
Yeah, so the workers' compensation, but also work health and safety, are unusual in that they talk about reasonable management action taken in a reasonable way. From an employment perspective, they're actually two halves of the same coin, whereas the workers' compensation and work health and safety, they split them up. So they'll look at the reason for doing something and the way you did it. And so obviously from the employer's perspective, to set themselves in the best position, they need to be able to articulate at an early stage what they're trying to achieve. And then they've also got to look at whether there's fairness in the process that they're doing, carrying out the actions. Now, I should say that, again, it's an issue, especially in workers' compensation, less so in work health and safety, only because work health and safety have a reluctance to be involved in this sort of murky area. They tend to push it off, whereas workers' compensation don't get that benefit. They've got to deal with the site claims that come in. It helps immensely if, the employer can show that they had a process that had been thought out beforehand, either with a formal policy or with an agreed plan of action before they undertook the management action. If there was a need to deviate from that process or plan, they can show that there was a considered discussion as to why there was a need for deviation and what the deviation was that was taken, so that you don't have the complainant saying, you said you were going to do A, B, and C, you only did A and C, you didn't do B. And if you can show that we decided not to do B because of a certain set of facts, whether it be trauma-induced, trauma-informed questioning, etc. That's all someone refusing to engage in the process. And then the last step is, once you've completed the process, that if you do decide to take an action, that it's being stress tested by an objective point of view, whether that be an external lawyer or someone within the organisation who's looking at it from a skeptical point of view, saying, what's the worst that could happen? And I say this not to be judgmental, but often the HR team will run this process, and the HR teams only have that one opinion looking at the whole time, and you don't get a second opinion to go and stress test what they're doing to make sure that an outsider, so to speak, would think that's A, a good reason for taking the action, and B, that it was done in a fair way, that the person's had their say, the say has been heard and duly considered, and that the action is commensurate to wherever the complaint might have been.
So true, Sean. Brilliant answer. Pivoting to you, Claire, in terms of employment, we've got unfair dismissal, general protections, discrimination, unlawful termination. There's a smorgasbord available to employees right now. And I appreciate defences and practical steps may vary, but what can we leave leaders with in a semi-succinct way to empower them to put their best foot forward if they end up in court?
Yeah, no, totally. There are so many claims, and aided by AI, we're seeing a huge spike in all sorts of complaints and claims,
Right.
really driven quite voracious correspondence from complainants and all that. I think in terms of what you can do to best prepare for those sort of claims, at the risk of sounding like a lawyer, I would say documentation is critical. If it isn't documented, it becomes a contest of memories. So that is a key. Keep file notes, document your process, have letters and emails, and don't. The amount of clients that sort of say to us, and you'll both recognise this, oh yeah, I've had 7 or 8 informal conversations with them, but there's absolutely no record anywhere, makes it really difficult. And again, as I said, it's a contest of memories. Secondly, I think a process. So as Sean said earlier in this podcast, you don't need perfection, you need fairness. I think tribunal members, like Fair Work Commission members, are generally more forgiving of a reasonable decision reached through a fair process than a perfect decision reached through a poor process, if that makes sense. Yeah.
Yes.
And then I think the other thing is probably capability. So prevention always better than cure. So if you invest in manager capability, particularly around that difficult conversation piece and psychosocial risks and performance management, I think that delivers a really solid return to organisations. So that is something that I would really focus on as an organisation. I think the most expensive workplace investigation are generally the ones that could have been resolved with a better conversation 6 months earlier. And so I think that there's the saying, it's kind to be clear. And I use that as a personal mantra quite often. It's kind to be clear, have the difficult conversation, have the upfront conversation. It stops a much more difficult process down the track.
That's so true, and it's something even I have to keep reminding myself of. But an accidental pitch for our Beyond Compliance offering there, Claire, also much cheaper than the cost of the court case. So thank you for that. You'll be our future host, I think. All right. It was so nice to have you on the program. Thank you so much for joining us, and thank you for your practical insights to our listeners. And thank you to you all for tuning in. As always, please get in touch with us if you have any questions or want to chat to us about anything we've covered today. You can find our details on our website, hallandwilcox.com.au, or connect with us on LinkedIn. If you've enjoyed today's episode, then rate, review or subscribe wherever you get your podcasts. Thanks again, and we'll catch you next time.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.